Good afternoon, everybody. A really warm welcome from everybody at the Survivors Trust. I'm joined by my colleagues, Julie and Chris. We're all listeners, so we are looking forward to answering your questions today. Thank you for taking the time to join us.
The role of an ISVA is to support survivors who have experienced sexual violence and abuse. An ISVA is trained to look after your needs and to ensure that you receive care and understanding. They will help you understand how the criminal justice process works and will explain things to you, such as what will happen if you report to the police. An ISVA is there to provide you with information only so that you can make the right decision for you. By contacting them, you are not expected to report any offence to the police. You can report a sexual assault or rape that happened at any time to the police, even if it was months, years, or decades ago. If you are going through the criminal justice system, your ISVA can support you throughout the process. They will talk with the police and the Crown Prosecution Service on your behalf for updates, which can help you to understand what is happening and what will happen next. The support can also be practical, such as liaising with other professionals like your GP or finding other services that can help, such as counselling or other talking therapies.
That's perfectly normal and understandable to be feeling anxious and overwhelmed. I mean, it's even, seasoned police officers, detectives who have to give evidence in court, they feel similar. They get overwhelmed, they get stressed. I think the good news is it's never how you see on the TV. It's never as dramatic as that. And there are kind of things that can be put in place and you can get support to kind of help you through that process. You're entitled to have what's called a pre-trial court visit, and organisation called Witness Services who sit in the court, and they're a voluntary organisation, and they do this kind of thing all the time. They support victims of all types of crime. You can have as many court visits to the court that you're going to be giving evidence in as many times as you want. So just to familiarise yourself where you're going to be waiting, where you're going to sit. They'll let you go into that courtroom when it's empty, usually over a lunch break, to get a feel of where you're going to stand, who's going to be there. So that's and they'll outline the process around the trial process as well. The other thing that you can arrange with them is there might be a separate entrance that victims and witnesses can access. A lot of times, witness care unit they're the ones that liaise with the police and the courts, will invite everybody who's a witness to that trial at the same time. And if the defendant hasn't been remanded, then everybody could turn up at the same time at the court entrance. So just being mindful of things like that, sort of staggering your times, speaking to witness services and make sure they can organise that. You should also be entitled to what are known as special measures. So anybody that's a victim of a rape or serious sexual offence is classed as a vulnerable victim. So therefore you're entitled to special measures. And they include, you can request a screen or a curtain around you while you're giving evidence if you go into the dock. When you have one of them, the only people that can see you will be the judge, the 2 barristers, and the members of the jury, 12 members of the jury. You can have the option to give evidence via video link. That means you usually sit in another room, and it's a little bit like doing a webinar, if you like. You can only see who's asking you questions on the other side of the camera, but the kind of downside of that is everybody in that courtroom can see you on there. Another tip is you're entitled to watch your video evidence before the trial. So that is usually played at the start of a trial. You're entitled to watch that at least a week before the trial. So it's usually, again, witness services or the officer in the case can arrange that. So kind of having as much preparation as possible, I think, is really helpful. Tips for actually what you'll find is the build up towards giving evidence is worse than when you actually get in there and start giving evidence. Once you're engaged in that process, you get a feel for who's asking you the questions, the sort of questions. They're not allowed to shout at you or say horrible things. Judges are quite strict with barristers. and one sort of tip that I've often give to clients is, if you see the face of a member of the jury that you think looks particularly kind, just look at them, focus on them, or look at the judge, or the prosecutor. Breathing techniques, sort of count to 3 and breathe in slowly and out slowly, and take your time answering your questions. I think, remember that you're not the one on trial. You're not the one on trial. You're just there to tell the truth and give answers. And even if you're asked a question that possibly the answer might sound bad, it doesn't matter. Still tell the truth, because it's the responsibility of the Crown Prosecution Service to succeed in this trial. You're one part of a larger jigsaw puzzle. They have overview of it all. So if they think that an answer didn't sound very good or needs clarification, they will stand up and they will ask that question, or what did you mean, or extend that. So don't worry about kind of what you say, just tell the truth. If you can't remember, you can't remember. If you don't know, you don't know.
When you're looking around that courtroom, if the witness box is closed off, so nobody can see what shoes you're wearing, you could always wear slip-on shoes, take your shoes off. That might help you to feel more grounded. If there's any long silences, that might just be a technique to make you feel like you haven't answered the question. So if there is long silences, that can be a bit of a tactic used by the defense. So just breathe, wait for the next question. Absolutely fine. And direct your answers to the jury. Find somebody in the jury that feels either familiar or comforting to you in any way. Maybe somebody looks like somebody that you know, but it's the jury that you really need to be communicating with. And it's up to the Crown to put that case forward. So just keep on remembering that. Yeah, and good luck. Most of the time is don't need to break confidentiality, and we really do take confidentiality extremely seriously because of the nature of the conversations that we're having. However, if the ISVA becomes aware of any safeguarding concerns, then that might need to be shared. So safeguarding concerns might mean that a child is in danger. It could mean that you are going to be in danger, or maybe an adult that is classed as vulnerable or has care needs. So it really depends on what's being disclosed, but 9 times out of 10, no, it would be completely up to you whether you wanted to report something to the police or not. And before you access ISVA support, you should be well aware of the confidentiality kind of limits, if you like. So that will be explained to you beforehand. And if it's something that has happened non-recently, then you can talk about it with an ISVA, you can get advice, and you can be as kind of abstract as you like. You don't need to give details. ISVAs do not work for the police. We are entirely independent. And so you can give us an outline, if you like, and give us a scenario, but unless we know the details, then we wouldn't be looking to share that with anybody. And when we do share information, we usually will tell people first, unless it's going to put them at further risk, which is very, very rare.
Yes, yeah. This actually applies to adults and children. You are still entitled to access therapy. The Attorney General's guidelines are clear. The police or CPS have no say on whether a survivor of sexual violence can access therapy or delay therapy. A pre-trial trained therapist will know how best to handle the situation. The most important matter is the welfare of the adult or the child, and that you get help as quickly as possible to avoid your mental health declining.
Yeah, good question. How exciting. So there are usually helpline or volunteer roles in each area. Have a look at what's available in your area, see whether there's any volunteering work that you can do. You will be trained to a really high standard. Usually we train volunteers and paid staff exactly the same. So I would first of all look at volunteering opportunities. You've also got your sexual assault referral centres, your SARC. So that's where somebody will go for a forensic medical examination if they choose to, after they've had a recent incident. So that's great experience as well. And when we're recruiting into the sector, if you like, we're looking at what somebody's work experience has been, what their life experience has been, and whether it's volunteer work or paid work, it's along the similar lines. When you work with vulnerable people, are you passionate about working and supporting survivors? But those are the types of things that I advise people to do. You can absolutely complete your ISVA training as well, so that you've got that qualification in your hand when you're going for the ISVA job. And I'd be more than happy to talk to you if you wanted to get in touch with us about our training. But I do think it's important to get things on your CV that show that you are really passionate about supporting survivors and, you know, volunteering. You could contact us about our helpline as well, where we're always looking for volunteers, and that will show you what it's like to support survivors and give you some really excellent training and skills as well, which is going to look good on your CV. So yeah, good luck.
In a nutshell, yes. So your ISVA, once your ISVA takes you on as an individual, as a case, then they should carry out quite a comprehensive risk and needs assessment to help develop a support plan, if you like, that's agreed with you. And that assessment should really look at all areas of your life. It's sort of the psychological, emotional component, how you're feeling, what you're thinking, any sort of sexual health needs that might be relevant, access to any kind of counselling, dealing with other reports to the police, housing, any kind of area around drug and alcohol misuse, finance, basically every area of your life that you come into contact with that ISVA is the chance to get that support around it. It will depend on the services available locally in your area, but I would say yes, in a nutshell, an ISVA should be able to support you with another crime, as long as you're under that ISVA support for sexual violence crime.
Absolutely. I mean, it's really common if the abuse happened in childhood that the memories are not going to be there. They're not going to be easily retrievable, which is a good thing. It's also very upsetting. So you may have snippets of memories of things that have happened. I think talking this through with an ISVA can be really useful, because we can explain what your reporting options are. You could report your abuse anonymously, and an ISVA can help you to do that. So, excuse me, it might be that you are telling somebody what you do remember, and then all of your personal details will be taken out of that report so that nobody can identify you, but it will have the details of the person that's abused you. And so the police will check their records and see if there's been a similar crime reported in the past. And then they'll call the ISVA and let them know. That sometimes is a nice, gentle approach into the criminal justice system if you're not sure. But then we can also think about, in any investigation, there are many different things that the police are looking for. So they're trying to create a really clear picture. And imagine it's like pieces of a jigsaw puzzle. Your statement is one piece of that jigsaw puzzle. They might talk to other people that were around you when that happened. They will ask you who's the first person that you've told, and they will likely interview them. They may also look at things like medical records, education records, could be social care records. So there's other pieces of evidence that they might be able to get hold of. I definitely think it's worth thinking about it. And, you know, the way that the criminal justice system should work is that the people that are investigating these crimes and also, you know, bringing them to our courts are trauma informed enough to understand that very often memory is fragmented, and there's a very good reason for that, you know, particularly when you're young, when it happens. It's pretty clever the way that our memory can just not let us retrieve things, at the same time as being really confusing and really difficult for survivors. So I don't want to underplay that, but the police should be quite confident in communicating with you, talking to you about your options and seeing whether it's something that you'd like to pursue. So my best advice would be get in touch with an ISVA and talk to them about what that reporting process might feel like. And if you choose to do that, then they can support you through that process.
Okay, so if the police don't think there's enough evidence to take the case forward, then they won't pass it to the CPS. The police will explain to you why they've made this decision. No further action does mean that the case will be closed, although if there is no information or evidence in the future, the case could be reopened and reinvestigated. You can ask for a review of this decision, and this is called the Victim's Right to Review Scheme. And this is where a senior officer who is not involved with the case will look at the case again to see if they think the decision was correct. You must request a review within 3 months of the police's decision not to prosecute. And the VRR specifically relates to decisions not to prosecute. It doesn't cover whether the crime recording decision or the decision not to continue with inquiries. You can also use that scheme actually for sort of no further action decisions made by the CPS as well. I hope that answers your question.
Brilliant, thanks, Julie. I've also had cases in my career where the police have decided there was insufficient evidence to be able to take those individual cases to charge, but then other victims have come forward, and because it was the same perpetrator and it's what's called similar fact evidence, they were able to reopen those ones that have been no further action. So, and I think to kind of give you some comfort as well, it's on record. It's on record. So even at that stage, it doesn't go anywhere. It hasn't got enough evidence. It's on record, so it's not going anywhere. And then you've got your civil court option as well, which is, you know, it's a very lengthy process. It's quite protracted, and that is based on probability rather than beyond reasonable doubt. But again, you'd need to speak to a professional to support you through that option, really.
Yeah, I mean, it depends on the judge, essentially. That's one of the special measures that you can apply for. So Chris was talking earlier about the screens being around you, and one of the, you can certainly ask the judge, is it okay if the ISVA comes in? And so the ISVA will sort that out. You don't need to approach the judge. And most of the time, judges are more than happy. The ISVA will sit silently next to you. They will need to be quiet and not look at you. Essentially, they need to show the court that they're not coaching you in any way. So they will be physically next to you and they will be with you, but they won't be able to take part in communication, things like that. But it can be a real cause, source of comfort for people. So absolutely.
I think if that young person has already got an established relationship with their pastoral support, then that's fine, because and I've done this in the past, if somebody has already got another professional that has built up that relationship with them, ISVAs can work alongside that professional and guide the professional and best to make sure that person's rights, what their options are, and then it can be a matter of then that professional can kind of introduce you into that support dynamic. So there's kind of different ways. I think you have to respect that individual's choice of around that support and who they feel comfortable. So I think there's different ways of doing it, really. And of course, it's like it can be overwhelming, especially for a child, if they've got, they've suffered, some kind of horrific abuse. They've got all the kind of effects of that to deal with, and then they've got different professionals, social care, family courts, whatever's going on. It's overwhelming, it's too much. So just having that single point of contact and that one support mechanism and giving them the support of an ISVA is a good way around that, and to introduce that, really, and maybe build up that child relationship with that ISVA.
Yeah, with regard to will the suspect be arrested? I mean, this will depend upon when and what has happened. So if the police have reasonable grounds for believing that the person's arrest is necessary, so for example, if they're worried about your safety or the safety of others, then the suspect is likely to be arrested. Sometimes the suspect may not be arrested, but be contacted and asked to go into the police station for an interview, sort of on a voluntary basis. With regard to making a decision to charge, when the police have actually finished their investigation, they will send all their evidence to the Crown Prosecution Service, who will then decide whether the suspect should be charged with a criminal offence. When the CPS decide to proceed, with a court case against a suspect, this is the formal process then of them informing them that they must go to court. When deciding this, the CPS lawyers must consider a two-stage charging test. So they will first consider whether there is sufficient evidence available for there to be a realistic chance that the defendant will be convicted at court. If there is sufficient evidence, the CPS lawyer must consider whether or not a prosecution is in the public interest, and it is almost always in the public interest to proceed with a prosecution for sexual or domestic violence as well.
Lack of context here, but presuming that the abuser has already been reported to the police for another offence, then, and depending on whether the abuser has been arrested and bailed, then there could potentially be breach of bail conditions, or if not, if there's no bail conditions, it can be, and also it can be construed as witness intimidation in terms of that. So effectively, any other charges, if it is a breach of bail conditions or witness intimidation, it follows the same process as any other criminal offence in terms of they need to gather the evidence for that. They need to check the threshold test for probability, etc. And if that's so, then that might be pursued in a different criminal case, or the CPS might decide that they put that together, depending on what the other offence is. I think probably there are national organisations that deal specifically in stalking and harassment that can probably give you more specific guidance to your particular case and give you that support, and we can share those details in the chat. I'll just source them now, but yeah, it's probably better you get some kind of direct advice really about your situation.
There's a function on our website that can also help you to find an ISVA service that's near to you. If you are looking for ISVA support, then please do contact us or have a look at our website. We do have an ISVA service here at the Survivors Trust, but it's for people that do not have any access to ISVA support. So we are able to support a few people throughout the country, but if there is an ISVA service near you, then it's much better if you can contact them, and then you'll have the option of potentially face-to-face support as well, and they'll be much more aware of what's going on around you in your local communities. They'll be a better place to support you, essentially.
Basically, yes. Once you've gone down that formal process of reporting to the police and you've give your statement, your video statement, then essentially you're in that process for police to investigate that and potentially charge a suspect, and depending if they pled guilty or not guilty, you could be looking at going to court. However, you can withdraw at any time in that process and re-engage, and it happens. It does happen quite a lot, you know. The police just need to kind of identify, and this would be part of the evidence, is why you chose to withdraw and then restart that. It's just all part of that evidential thing. But definitely, if you've given a formal statement in terms of video, it's likely if it does go to court, you would be cross-examined.
Chris, I was just going to add something on to that, because I know you covered it a bit before about the special measures.
Yeah.
So, yeah, just going to sort of add that they can apply for special measures. So, you know, it could be behind a screen or using a live link, or actually in some occasions, you know, the video recorded cross-examination. So there are sort of things in place that you can apply for as well.
Yeah, and can I add something as well? When the police take that initial video evidence, so the ABE, achieving best evidence is what it's called, usually, they might ask some difficult questions, and it may be that they are asking some difficult questions so that that does not get asked of you in court. So it's worth knowing that. Not all victims and survivors know that, but when the police take that first video statement, they will likely ask you some difficult questions, because it will just be you and them. And if they can get that onto the video that they've asked these difficult, challenging questions, then it doesn't need to be asked of you in court. So that's just something to be aware of, really. It can feel like, why are you asking me that? Don't you believe me? It's not about whether they believe you. It's they want to hear your answer. They want to make sure they've captured that rather than you be cross-examined in court, but they should be explaining that to you as well.
Yeah, I mean, they should be able to support family members as well, but I believe that if they won't be sort of seen any sort of quicker in any respect. So if they're on the waiting list, they are going to obviously, you know, predominantly is all going to be about the survivor, and really they're the priority. Here at the Survivors Trust, you know, Helen's touched on it before, the online service. We can actually offer initial advice, so we'd be very happy to give that support, like emotional support to family members.
Yeah, we have the type of support we usually offer to family members is usually referrals or signposting, and usually that mediation as well. If there's kind of any misunderstanding or conflict or issues, stress or tension between the client and a family member, we can usually offer to kind of mediate in those situations. I think it's children in particular often have asked me, can you get my mum off my back? She's doing my head in. Yeah. And it's usually because, you know, mum, as you would be, is just, you know, going out of her mind. She's worried sick. She feels responsible. She feels guilty. She wants to feel like she needs to do something. But most of the time she doesn't need, there's nothing, it's just being there is sufficient. And it's just kind of reassuring that person, you know, if your child's just been through a traumatic experience, if they're sleeping all day, you know, it's fine. Yeah, it's fine. This is sort of a normal trauma process. So that's kind of support we can give. And if we feel they need extra support, yeah, we can refer them on. Police can decide, and it is police and CPS who will make that decision of whether they want to prosecute individuals on an individual basis or together in a whole court case. So that really does depend on the circumstances, and it's a CPS and a police decision.
Last question. I'll see whether I can cover lots in that, shall I? So when ISVAs originally came about, if you like, when they were first created, initially everybody agreed we're going to offer support before, during and after the reporting process. So yeah, my answer is they should be offering support after a court case. So the type of support that you can be offered, it might be that you are ready to access therapy if you hadn't been before. It might be that you had been putting things to the back of your mind that, you know, you didn't have the capacity to really concentrate on, and that might have been education. It might have been something to do with your career. It could be a house move. It really could be anything. Most of the time after a court case, things will resurface that you have been put into the back of your mind, and the ISVA will want to do another kind of assessment and see what your needs are. And most of the time it's not endless support, because ultimately we want to empower people to be absolutely fine about an ISVA. So it might be that there's referrals made for other support from other professionals. We're going to want to check that you've got things in place, that you're feeling safe, and that you feel like it's time to end support. We'll always be there. You can always come back in for support. There might be exceptions in certain areas where there are likely going to be funding restrictions, in which case if you cannot access support after a court case, it's pretty much always down to money, down to funding, and down to the capacity of the service. So yeah, I think let's be real about the way that it is at the minute. There are a lot of waiting lists for accessing ISVA support, and so we're having to get creative in how we're supporting people. And some agencies are saying, unless you have reported, we can't support you. And once the case is finished, we'll be looking to stop support. But I would hope that where we can, we're doing that as holistically as possible, essentially, that we're keeping the survivors' best interest, best wishes at the heart of the support that we're offering, because that's what ISVA support is all about, really.